Good evening and welcome. You're watching The Last Word. I'm Vedanta Agarwal. Our special focus on the show this evening. From the streets of the national capital to the courts of Delhi, it has been a long battle between the Aam Aadmi Party and the central agencies. 6 months after the unprecedented arrest of the Delhi Chief Minister, a first for a sitting Chief Minister, Arvind Kejriwal has walked free after a strongly worded order from the Supreme Court. While there was consensus on his bail, the two judges differed on the legality of the CBI arrest. While Justice Bhuyan called the CBI a caged parrot and the trial a travesty of justice, Justice Suryakant said the arrest was legal but emphasized the fact that bail is the rule. The bail order, right in the middle of peak poll season, has wide-ranging political ramifications. The task is cut out for the bailed Aam Aadmi Party brass, consolidating the beleaguered cadre and putting the Aam Aadmi Party house back in order. On The Last Word tonight, we ask, with the Chief Minister set free, is CBI still the caged parrot? Before I bring in my guests, listen to what Chief Minister Arvind Kejriwal had to say after he walked free.
कि केजरीवाल को जेल में डाल देंगे तो केजरीवाल के हौसले टूट जाएंगे। आज मैं आपको कहना चाहता हूँ, मैं जेल से बाहर आया हूँ, मेरे हौसले 100 गुना ज्यादा बढ़ गए हैं। मेरी ताकत 100 गुना ज्यादा बढ़ गई है। इनकी जेल की मोटी-मोटी दीवारें, इनकी जेल की सलाखें केजरीवाल के हौसले को कमजोर नहीं कर सकती। मैं भगवान से प्रार्थना करता हूँ, जैसे आज तक ऊपर वाले ने मेरे को रास्ता दिखाया, ऊपर वाले ने मेरे को ताकत दी, ऐसे ही भगवान मुझे रास्ता दिखाता रहे, मैं देश की सेवा करता रहूं और ये जितनी राष्ट्र विरोधी ताकतें हैं जो देश के विकास को रोक रही हैं, जो देश को बांटने का काम कर रही हैं, जो देश को अंदर से कमजोर करने का काम कर रही हैं, जिंदगी भर में इनके खिलाफ लड़ा हूं, आगे भी ऐसे लड़ता रहूंगा।
And joining me on the show this evening, our big newsmaker on The Last Word, Dr. Abhishek Manu Singhvi, Senior Advocate of the Supreme Court, of course, Arvind Kejriwal's counsel. Dr. Singhvi, thanks very much for being with us. You really have been, at the forefront of this protracted legal battle. Before I get to the details of the bail order, let me ask you right at the outset, how difficult has this case been? Because of course, we have seen in the past a couple of years particularly, getting bail in a PMLA case is anyway extremely difficult. And then when Arvind Kejriwal got bail in the ED case, you had the CBI arresting him. So how difficult has this case been? What have been some of the most difficult challenges for you, representing the Chief Minister of the national capital, the sitting Chief Minister first in history, a sitting Chief Minister being arrested?
Well, I think in a sense you hit the nail on the head. All such cases are difficult because not only are they in special statutes, not this one, but all the earlier ones, but also because they are under cynosure of political intersection of politics and law. And that cynosure of eyes, the streaming media, and the general political overtones have an effect, I think, on the entire atmospherics and the ambience. So they are difficult cases. But this one is bizarrely difficult. And let me tell you why I say that. I don't know of any case, certainly not any I have done, and very few others would have done, where I have got for you 3, not 2, not 1, 3 release orders under a statute which makes it very difficult to release you, puts a special bar, has section 45, etc., etc. I get you those release orders. The CBI has issued an FIR against you in 22. It has interrogated you for 9 hours in 23. And 2 years later, 22 months to be precise, when I have got 2 release orders under PMLA and one comes later on the 12th of July, in between that, at the end of June, CBI comes and arrests you. Now that's why I am the first one to use the phrase insurance arrest in late June 2024 when this happened.
Yes.
Now, the judge today, one of the 2 learned judges, has used the word frustrate.
Yes.
possible release. And I think the sentiment is the same. I don't think CBI should leave the path of some decent amount of objectivity when you have got from a much more difficult statute on the same cause of action, on the same predicate offense, on the same offense, bail or release orders. I think it was very unfortunate in this case, and it was clearly to my mind. I keep my law and my politics apart. But clearly to my mind, a political move to take this action against him at that belated stage should never have been done.
Right. In fact, if you go through the order, the essence is certainly something that the Supreme Court has reiterated time and again, that bail is the rule and jail the exception. But there was this sort of difference of opinion on whether the arrest was legal. Now, that, of course, is something, it was a difference of opinion between two judges. But in your opinion, as Arvind Kejriwal's lawyer, do you see this trial as a travesty of justice? Because that's an important point. That's something that the Supreme Court said even in Manish Sisodia's bail, that the trial and the investigation has been a travesty of justice. Would you agree with that, and why so?
If you talk of the trial, the same facts and the same context applies to Arvind Kejriwal as does to Sisodia. The court in this order today has not dealt with the details, but the facts are the same. And both judges have unanimously concurred in bail. And one of the reasons both have given is the inordinate potential delay of an ongoing trial, which, by the way, has not yet started. The word trial itself is wrong because trial has not started. You are in most of these cases with hundreds of witnesses, 80,000, 90,000 digital documents, thousands of other non-digital documents. You are at the stage of the accused being given inspection of the documents under the provisions. So, and both judges have observed today, of course, in the Manish Sisodia case, which I did, the courts have observed in great detail the delay. Now, that links to a much larger and a more important issue, which is a great advance in the law in these cases. And I am privileged to have been able to assist. That is that ultimately in PMLA, which is a much worse statute than CBI's action, it's only a statutory provision which denies you, isn't it? Yes. The statutory provision denies you, or supposedly partially denies you. But they said when there is delay, there's a higher provision to that, the article of the Constitution, which says delay defeats your rights as a criminal accused, and therefore we will hold, and that's been held now. So there are other cases.
And ultimately, as the Supreme Court has also pointed out, it undermines the right to liberty. It undermines the right to liberty, and bail is sacrosanct. But Dr. Singhvi, if you look at the order, some of the conditions that have been imposed by the Supreme Court, though there has been no new condition, there are similar conditions to the ED matter. But would you say that this, in a sense, would curtail the Chief Minister from virtually being a Chief Minister, a functional Chief Minister, given the fact that there's limited authority, limited access to the Chief Minister's office?
Well, that's what political opponents like to do. That's what obviously people who cannot remove an elected chief minister would like to say. But people are forgetting one other basic point. As you said, this is nothing but a continuance of an earlier order of 12th of July. There's not a comma full stop change. But what people forget is that Kejriwal has never held any portfolio. So in any case, he does not sign any files, except one category. That only category where he's obliged to sign files are those which will not go from the office of the government to the LG.
Right.
Now that category is specifically permitted by the Supreme Court order. He can sign and should sign those files. So in that sense, governance being affected is an overstated thing. It's a political hype. And now that he's physically free, governance cannot possibly be affected because his ministers are there as far as file signing is concerned. Those files which go through him and must go through him, he's entitled to under the same order. So this is, I think, an overhype because ultimately you must remember that crimes cannot be basis unless proved.
Absolutely.
To be removing you from elected office.
Right.
The elected has to remove you.
That's a fair point, I think. And Dr. Singhvi, the details aside, certainly a huge victory for you. And of course, the Chief Minister, thanks very much for being with us and giving us your sense of the order. I'm also being joined by Akshay Marathe, National Spokesperson of the Aam Aadmi Party. In fact, he will be joining us in a short while from now. Also, Colin Gonsalves, Senior Advocate of the Supreme Court. Charu Pragya, National Spokesperson of the BJP, is also with us. And Deshratan Nigam, Senior Advocate of the Supreme Court. Thanks all very much for being with us. Charu, going across to you first, your first response. I mean, the politics of it aside, would you not concede that, this is some sort of a shot in the arm for the Aam Aadmi Party? You had both the judges, even though there was a difference of opinion, both the judges saying that, bail was long overdue. In essence, that was the argument. And, this release coming right ahead of the Haryana polls, assembly elections early next year, it is certainly a boost for the Aam Aadmi Party. And now, effectively, the entire Aam Aadmi Party brass is out of jail. Does that make you nervous?
Not at all. Good evening. The bail was always up to the learned lords of the judiciary, and up till now, they are the ones who saw it fit to not grant bail. So let's not take away from that. Also, a highly conditional bail is in no way an acquittal, and I don't know why Aam Aadmi Party is treating it as such. They should be cautious at best. And the conditions of the bail are such, and I was just listening to Mr. Singhvi also, the conditions of the bail are such that the Chief Minister is not really acting as the Chief Minister anymore. He is unable to go to office. He can't sign any files. He can't even go to the Delhi Secretariat. But according to Mr. Singhvi, that is nothing new. So that makes me question, what is he doing as the Chief Minister of Delhi if neither now nor earlier he was ever taking responsibility and onus of anything that went on in Delhi?
But Charu, the point here is that governance wasn't really hampered even in his absence. Governance wasn't really hampered even in his absence because he doesn't hold a portfolio. He's a Chief Minister without portfolio. But politically speaking, now of course his focus will be infusing the cadre. So politically speaking, yes, go ahead.
Yeah, let me finish. So, yes, you're right. He didn't hold any portfolio. So what does that mean? That means he enjoyed the powers and the title without any responsibility. And these responsibilities, which he did hold in the past, like for the Delhi Jal Board, he used them to sink the department into the ground. Nobody else has been able to salvage it since.
Okay.
So today, it makes me wonder, why are the people of Delhi being held to ransom? For a political party which won Delhi elections with a thumping majority, 62 MLAs out of 70, can they not find someone to replace the CM if the current one has been behind bars for over 160 days?
So those are larger points you're making, but the point you made about the Chief Minister not being able to function as a Chief Minister. Let me get Akshay Maran. I'll come back to you, Charu.
Can I just repeat?
Okay, go ahead.
Okay, I just wanted to answer your point about infusing energy into the cadres of the Aam Aadmi Party. So Arvind Kejriwal was also out on an interim bail during the 24 general elections. We saw that. He was here. Yes. He was trying to infuse his cadre with new energy, but we saw the result of that. Aam Aadmi Party lost all 7 seats in Delhi. In fact, got into more scandals. The Swati Maliwal controversy happened at that point of time. Controversial statements were made. So they lost instead of gaining.
Point taken. Akshay Marathi, a quick response to what Charu Pragya is saying about the Chief Minister perhaps not being able to really function as a Chief Minister because he has limited authority. He has no access to the CMO or the Secretariat. In fact, the order also mentioned that he would not be able to sign on a document without the LG's approval. So will he, in a sense, effectively cease to be the Chief Minister despite being on bail?
Vedant, I will come to that technicality in just a bit, but let's look at the big picture of what has happened today.
Sure.
The big picture is that the two investigative authorities, the CBI and the Enforcement Directorate, who both together controlled directly by the Bharatiya Janata Party government, tried to entrap Mr. Arvind Kejriwal and the other leaders of Aam Aadmi Party in fake cases and try to keep them in jail away from their public duties, away from their public campaigning duties before elections, have been exposed thoroughly by the Supreme Court. I want to read out the relevant sections of the Supreme Court's order today, Vedant, because it's very important. The Supreme Court has specifically used the word caged parrot in the para 32 and para 33, where it says, like Caesar's wife, an investigating agency must be above board. Not so long ago, this court has castigated the CBI, comparing it to a caged parrot. It is imperative that the CBI dispel this notion of it being a caged parrot. So the question is, if the CBI is a caged parrot, as the Supreme Court has called it today, who has caged this parrot? It is the BJP who has caged this parrot. It is the BJP on whose specific direction Arvind Kejriwal ji was arrested from custody in Tihar jail. Let me just go back in time. Mr. Kejriwal was in Tihar jail under the ED's custody. And before he got bail, just one day before he got bail, the CBI suddenly decided to arrest Mr. Kejriwal. Today, the Supreme
So
Court
those
is
are serious
also...
questions.
No,
Charu
no,
Pragya has a
there are
point.
some
But
factual
Charu,
errors.
let me quickly take
There are
opening
some
remarks
factual
from
errors.
everyone. Deshat and
No,
Nigam
I
is also
understand,
with us.
but Akshay is making some
I'll
factual errors in
come
his
to you. I'll
statements
come
on
to you,
your
Charu.
show.
Let me take opening remarks from everybody. Deshat and Nigam, your remarks on what the court said about the CBI, because the court said that it's not just about the technicality, but it's also about the perception of fairness when it comes to our central agencies, our investigating agencies. Those are sacrosanct when it comes to a democracy. So, has that image being tarnished with this caged parrot remark haunting the CBI again? I mean, it was not so long ago when the Supreme Court used that reference. In fact, various courts have used that reference for the CBI.
Well, Vedant, let me tell you, in 2013, the CBI was called a caged parrot, and subsequently the amendments took place, and the three-member committee consisting of the Prime Minister, Chief Justice of India, and Leader of Opposition decided to appoint the director of the CBI. That caged parrot effect was taken away from CBI so far as appointment and administrative control is concerned. Therefore, a kind of an independent, autonomous institution came into existence after that. So I think the observations of the Supreme Court was uncalled for. They should have confined this case, and rather than making an issue of perception is a very subjective and political thing. Perception is a kind of a thing.
See, what the Supreme Court has said was in the larger context. So, I mean, let's not undermine that, because what the Supreme Court said was that perception is also important when it comes to our investigating agencies, and not just technicalities.
Let me answer, Vedant. Supreme Court works within the strict boundaries of the existing laws, and perception is not part of that law. So this is beyond law. So perception will vary from person to person. I think there I don't agree with the Supreme Court, and calling it a caged parrot is something. I think that subsequent amendment had taken care of it. And so far as this aspect is concerned, bail does not mean a person cannot go to jail in future. So therefore, this is not an acquittal, and celebration may be fine. It may be a political thing, and the Aam Aadmi members are entitled to celebrate. I mean, you can't take away that right from them. And however, one important aspect is, if he cannot sign it, is there a bar that he cannot look into those files and orally guide the people? So these are very important questions that need to be answered. Remember, last time when he was released on interim bail, Supreme Court had said that please, you are not allowed to comment on the merits of the case, and he did so in the rallies. He said about the merits of the case, trying to prove his innocence. Will he again violate all those conditions?
So again, those conditions are extremely stringent. I take your point. But Colin Gonsalves, weigh in on this entire debate around delay in such cases, in high-profile cases. The sort of trials and investigations going on endlessly. In this particular case, we saw the CBI and the Enforcement Directorate both had filed their charge sheet, so the investigation, in a sense, was complete. But this idea of bail being sacrosanct, bail has to be given, bail is the rule. This is something that the Supreme Court has reiterated time and again in various cases. So, why this delay as far as our, investigations are concerned, particularly in high-profile cases?
Yes, if you read the judgment of Justice Guya, you will see that all the allegations that Arvind Kejriwal made against the CBI have been substantiated and accepted. First and most important, that he was the victim of targeted harassment. Can you imagine such a serious allegation against CBI? Second, that the arrest was neither necessary nor justified.
And again a caveat there that this was a differing judgment in the sense that Justice Surikant differed from that opinion. So that's one aspect of the judgment. But sure, go ahead.
No, correct. But the order is the order of a judge of the Supreme Court. It has a very serious implication, namely that it is illegal because it was not necessary and it was not justified. 22 months the CBI doesn't arrest him. The moment the ED releases him on bail, he gets arrested. So neither necessary nor justified. Tampering with evidence. The judge says the evidence is all documentary. It's not the evidence of witnesses who can be coerced to change their statement at some time, and therefore tampering charge goes. Then it says the snakes and ladders approach of the High Court, where the High Court had the matter in the High Court. The High Court and the Sessions Court have dual jurisdiction, and wasted time in sending it matter back to the Sessions Court to go through that up and down,
in fact,
roller
that game of snakes and ladders point was something that the Supreme Court said in the Manish Sisodia case as well. But Charu Pragya, you had a point. Go ahead.
And two things more.
Yes, I'll come back to Mr. Gonzalez. Charu, go ahead.
Okay.
So we are giving a lot of importance to the observations of one judge, but let's also remember the other judge very clearly noted that this arrest was not illegal. This arrest was entirely fair and it followed the Code of Criminal Procedure. So let's not take that away. Also, previously, the same Supreme Court has noted that up to the tune of 100 crore could have been spent in the Goa elections. They have also noted on record that a money trail does lead up to the Aam Aadmi Party coffers. Also, when the Aam Aadmi Party spokesperson calls this case as fake, is he the investigator? Is he the judge? How does he decide? And most importantly, it was his chief minister casting aspersions in the very same case on Manish Sisodia, on Atishi, on Saurabh Bharadwaj, even those who were not under the net, he's cast the net wider. So it's not like he's washed his hands of the case altogether. He's just tried to deflect the blame onto his juniors, and that's exactly what he's been doing by taking no responsibility
for any action, those allegations. But yes, Akshay Marathe, go ahead. Your response.
No, the reason that I'm calling this whole case a fake case is because the entire conduct of these investigative agencies has come into question today. In the last several cases, wherever the CBI or ED has filed cases in political matters, when those political leaders join the Bharatiya Janata Party, those cases get dropped against them. So based on that conduct, when you look at how they have gone after Arvind Kejriwal and Aam Aadmi Party leaders and have really, look at Arvind Kejriwal, he was in jail for 6 months. Manish Sisodia was in jail for 18 months. And in all this time, they did not even have it in them to start the trial. Tell me a simple thing, Vedant. If they think they are convinced that Arvind Kejriwal has committed some crime, start the trial, prove your case and convict him. But they don't have any evidence. That's the problem, which is why they wanted to keep him in jail for as long as possible so that the process became the punishment. And that's where
that's an important point. That's an important point I'm making. And Desh Ratan Nigam come in on this because, this whole thing about trial becoming the punishment, this has really been discussed at great length, not only in Arvind Kejriwal's case, but in many other cases. And also, there's no evidence that has been put out in the public domain by, the investigating agency, though, of course, a charge sheet has been filed before the court. But, what do you have to say on this point, that the investigations go on endlessly and the trial cease to begin?
Well, Vedant, yes, in Indian judicial system, we do require judicial reforms. Investigation, especially in such kind of cases, does not leave a money trail. You require a lot of investigation to connect the chain, the entire chain. There need not be any chink in the train or missing link in the chain. So it does require time. However, judicial reforms are required so that the under trials have to, immediately face the trial. But CBIs, thousands of documents and hundreds of witnesses and evidences before court, it does take time. How to do it, I think everybody has to apply its mind, right from the government agencies, investigative agencies, and the judiciary, as to how to speed up the trial, because there are a huge number of under trials still in jail who have not yet seen the completion of trial.
And I think that's a larger question of judicial reforms. Mr. Colin Gonzalez, the last word to you. You had a point to make earlier. Yeah, go ahead.
Well, I want to say this aspect of him not being allowed to get into his office and sign the files is a very interesting observation in Justice Goyal's judgment, where he says, I have serious doubts about an order preventing him from getting into his office and signing his files, which means that the issue is not closed. And it could well happen that if a 3-judge bench is constituted, then Arvind may win and get back into his office and sign his files. And that will be a good day for all of us.
That's a larger question, whether it goes to a larger bench or not. That really remains to be seen. But of course, this judgment has wide-ranging ramifications legally and politically. But the Supreme Court, in essence, setting the record straight that bail is sacrosanct, bail is the rule and jail the exception. Though of course there was a differing opinion as well. But even the concurring judge, sort of agreed to the fact that there has been a delay and bail has been long overdue. Thanks all very much for being with us. This is a story that we will continue to track very, very closely. The poll dangle has really gotten hotter with Arvind Kejriwal's release. That's all the time that we have on The Last Word this evening. Thanks so much for watching. Good night.